Yours in the bottom. You may be seated.
We're going to resume testimony. It's around 11 a.m. And for parties time-wise, I probably will try to break the lunch around 1. Okay, so we're going to keep going until 1, but if anybody needs a break, I don't mind. We'll take a break. Just let me know. All right, next witness.
Commonwealth calls Amy Kovac.
Okay. Amy Kovac, and I'm saying
K-O-V-A-C.
Thank you.
Stand here, face the clerk, raise your right hand.
Do you swear or affirm that testimony you're about to give is the truth, whole truth, and nothing but the truth? Thank you.
You're looking up on a second. You watch this step now. All right, chair rotate.
Good morning. If you can move the microphone if you need to.
Okay.
And please answer questions the attorneys may have.
Okay.
Good morning. Could you please tell us your name?
Amy Kovac,
Could you spell your last name for us?
K-O-V-A-C.
Thank you. Ms. Kovac, how are you employed as of today?
I work with Newport News Public Schools as a reading specialist at Newsom Park.
All right. And then I want to take you back to January of 2023. Were you also a reading specialist at that time?
Yes.
And where were you working?
Rich Neck Elementary.
How long have you been employed as a reading specialist total?
12 years total.
During your time at Rich Neck, did you know a student, and I'll remind you that we're not using any student names, so please keep that in mind, but did you know a student by the initials of JT?
Yes, I did.
How did you come to know JT?
Dr. Parker at the time had put him on a modified schedule, and I was his one-on-one teacher for reading during that scheduled time.
Okay. Do you know from your own observations and interactions why JT was on a modified schedule?
I had heard he had.
Attention to hearsay.
I was on the
Hold
modified.
on 1 second. Let's go back one. And how this works procedure-wise is they object, the other party gets to respond, and then I'll make a legal ruling, and then I'll let you know what to do. So, and just explain it to you. Okay, so defense is objected. Your response, Mr. Kennedy.
Your Honor, if there is hearsay there, I'm not trying to elicit that, so I'll try to rephrase the question.
Oh, yes, sir.
Ms. Kovac, did you have any personal interactions with JT yourself that led you to believe that he needed a modified schedule?
Not before the modified
Okay,
schedule.
understood. So you started working with him in a modified schedule. When was that?
It was in early October.
And tell us a little bit about how the schedule worked.
So originally the schedule, he would come to school at 9:20, get off the bus, and our counselor, Mr. Rawls, at the time would pick him up off of the bus and get him breakfast and set a goal for his day. And then he went down to Mary McBurnett, our K2 special ed teacher, where she was to do a social story. And then he was to come to me around 9:30 or 9:45 and for like 15-20 minutes do reading with me. And then Mr. Rawls would take him into Ms. Warner's classroom. And then he would leave around, I think, like 10:40, 10:45, get his lunch and then go home.
And you've mentioned Mr. Rawls. Do you know what his title was there?
He was the school counselor.
Okay, thank you. I want to speak to you about the morning of January 6, 2023, did there come a time when you were in the office that day with Abigail Zwerner and Dr. Parker?
Yes.
And while you were in that office, did you, based on what you heard in that office, did you have concerns?
Yes.
Okay. Later in the day, did you tell Ms. Zwerner to keep an eye on JT?
Yes.
Why?
Because 2 girls had reported to me that he had a gun in his bag.
Okay, what's your objection?
May I lay a foundation for the potential use of an exception, Judge?
Okay, give you a leeway, yes, sir.
You've indicated, I believe, that 2 girls spoke to you. We'll hold off on what they told you. Can you describe those girls' demeanor or behavior at the time they're reporting it to you?
Yes, I was walking past the room and the 2 little girls had come out to me and said that JT...
Oh, wait, hold on. Before you tell us what they said, what I want to know is how they appeared to you.
They seemed to be scared and worried.
Okay, what did you see in them, what in their bodies or their faces that made you think that?
The actions of them coming close to me, wanting to get my full attention and to let me know, and their faces were kind of like expressive to show worry and concern.
Okay, and eventually they do tell you something, again, without going into what they said. Do they relate to you about something that has just happened, that they've just seen in the minutes before?
I'm going to object to leading.
This is to establish a foundation to use a hearsay exception, Judge. It's
Okay, so Ms.
foundational.
Kovac, hold off on answering. Let me hear the full question, then I can decide on the objection.
Yes, the question is whether the report she receives is quick in time to when she received it. In other words, whether they are reporting something that happened within the last minute, because that's a foundational question for the excited utterance exception.
Mr. T.
You know, I think that's clearly leading. He's asking for, she has not even testified anything about what they said or how, she testified that they seemed scared or whatever, but he's giving her the answer by asking her, did they tell you something that had just happened right before you came in contact with them? I mean, that's his testifying to the witness.
Okay, well, let me pull out the excited utterance.
Rule 2803-2.
Rule 2803 of the Rules of the Supreme Court of Virginia reads, excited utterance, a spontaneous or impulsive statement prompted by a startling event or condition and made by a declarant with first-hand knowledge at a time and under circumstances negating deliberation. All right. Mr. Jenkins, I'm going to have to sustain the objection because she's not the declarant according to the rules. The declarant would be purportedly that child.
Judge, could we address this matter outside the presence of the jury, please?
We can. You want to meet me in the jury room or side room, or how would you like to address it?
If we can address it on the record, it doesn't matter to me.
Okay, so members of the jury, sometimes you get more steps in than you wish. I'm going to ask you to retire to the jury room, please, and I'll take up this objection.
I'd ask that she go into the witness room.
Okay, and one moment, Ms. Kovac, we'll wait for the bailiff to come. I'm not sure that door shouldn't be locked. We'll wait. Okay, members of the galley, you can have a seat. Okay, Sheriff, we're going to have Ms. Kovac step back into the witness room. Watch your step, please. Okay, yes, sir.
Judge, I'm sorry. Were you recognizing defense counsel or
No,
Meeks
no,
defense?
you
Okay,
wanted to take this up.
I do.
So the objective, and yes, your response.
I do. There are two things going on here, Judge. The first is that in an effort to keep things moving, I was asking foundational questions about the excited utterance exception, and if counsel prefers, we can do that as a voir dire of the witness outside the presence of the jury, because whether the excited utterance exception applies or not is a matter for the court and not the jury. So perhaps it would have been more appropriate for me to ask the foundational questions outside the presence of the jury. But regardless, in order to establish the foundation for any hearsay exception, I'm going to have to ask leading questions. So that is why it is usually not done in front of the jury, that we do that outside of their presence. As to the excited utterance, and I will request a moment to pull up some cases, but the rule reads, a spontaneous or impulsive statement prompted by a startling event or condition made by a declarant with first-hand knowledge at the time. When the rule says a declarant, it is not referring to the person on the stand, because then they would be here, the declarant would be here. The rule is referring to hearsay, that is the person on the stand reporting what they were told. But the declarant, in this case, is the girls. They are making a statement that is about a startling event or condition made by them, the declarant, at a time when they were still under the circumstances negating deliberation, because, as I was asking when counsel objected, how quickly were they reporting it? Were they reporting something that happened a year ago, or were they reporting something that happened in the last minute? That was the question I was getting at, to determine whether the statements that the girls made to Ms. Kovac were spontaneous. Ms. Kovac is the person in court today, but she's not the declarant for the purposes of the rule. The declarant is the out-of-court statement. And so if I may have a moment to find a case example, I think I will be able to.
Okay, you may, and I understand your argument, there's a distinction between a declarant and the declarant. And I'll give you a moment to find the case, but projecting this forward, how are you going to lay a foundation of how she would know how soon their statement was made to when the children observed whatever concerned them to when it was relayed to Ms. Kovac? Because you brought that up. Like, do you have a plan to flush that out?
I think we should flush that out before we bring the jury back in.
Right, so that's what I'm
yes.
asking. So just thinking forward,
I-
that will come next. But yes, I'll give you a moment.
Yes.
Okay, just let me know when you're ready. Hold on to the pencil. Let's find this case. And then I'll happily hear from you.
Can I step out while he's finding the case?
Sure.
What's the case?
One of them is Hicks v. Commonwealth,
What's the sub?
60 VA App 237.
60 VA app 237.
Yes.
Could you give me a moment just to look at that case up?
Sure.
Do you have a case, Mr. Rogers?
I do. I'm trying to just read it so I can.
Okay, well, we're gonna move on. Go ahead, but we're gonna have to do two things at the same time. Yes, Mr. Jenkins?
Yes, Your Honor. The case that I would cite for the court is Hicks v. Commonwealth, HICKS. It is 60 Virginia App 237, May 29th of 2012. I cite the case only because it is an example where a witness is on the stand and is allowed under the excited utterance exception to testify that the victim of a shooting said he'd been shot. So the declarant in that case was the victim who had been shot, excitedly declaring something spontaneously, while the witness in court was someone else entirely who just heard the out-of-court statement. That's what we have here. Ms. Kovac has heard, I believe we can do voir dire to ensure, has heard an excited utterance from these two children, and they are the declarant that the rule contemplates.
Response from the
Yes, Your Honor. I agree with Commonwealth that the declarant can be someone other than Ms. Kovac. However, in order for the excited utterance exception to apply, again, we can go to the death or the rule. Excited utterance is spontaneous or impulsive statement prompted by a startling event or condition and made by a declarant with first-hand knowledge at a time and under circumstances negating deliberation. Ms. Kovac cannot testify to whether these declarants had first-hand knowledge, whether it was at a time and under circumstances negating deliberation. She has no details about that. She would have, because she's not able to, the girls are not here, she's not able to testify to any of that. So the excited utterance exception would not apply.
So the court will reconsider its previous ruling, which I sustained the objection. I will now overrule the objection and allow Ms. Kovac to answer the Commonwealth's question, and the excited utterance rule does apply. Anything, what was the other point that we were going to consider? How are you going to lay the foundation to show the duration?
I would suggest, Your Honor, that before we bring the jury in, we have Ms. Kovac come back to the stand, and I will voir dire her briefly, just to establish the concern about the girls' knowledge of what they were reporting,
Okay.
whether it was spontaneous.
All right, we'll bring her back. Chief Sheriff.
When we left off, you were telling us about two girls running up to you. Could you please tell us what they said?
They said that JT had a gun in the back.
Okay. So upon saying that JT had a gun in the back, could you describe their demeanor in saying that?
They came up to me, they were kind of, like nervous and worried and wanted help.
Okay. Judge, I think that lays the foundation for her to say what the girls told her under the excited utterance.
How long after well, first of all, how did they know that Justice had a gun in the bag? JT had a gun.
I don't know.
You don't know, okay? So as far as you know, as far as you know, someone could have told them that, correct?
I don't know.
Okay. Your Honor, just based on that, I believe that this is, again, that she has no knowledge of any firsthand, if the girls had any firsthand knowledge, how they came to get that knowledge. And so then we run into hearsay, possibly hearsay within hearsay, if the girls heard it from someone else. She doesn't know. And so I believe, Your Honor, that this does not come in.
Response.
The standard in the site.
I'm sorry.
There's one other thing.
Okay,
No,
I'm
no.
sorry. Ms. Jenkins, yes, sir?
How do you know how long? Well, you don't know. You don't even know whether they saw the gun themselves, correct?
I don't know.
Okay. And you don't know. So there's no way for you to be able to know whether they are talking about a gun that was seen or by someone 5 hours ago, yesterday, correct?
I don't know. They reported and I acted.
That's my question. Your Honor, again, I don't believe it qualifies as a non-acceptable hearsay rule.
Mr. Jenkins.
The legal standard to be applied at this stage in determining whether an evidence exception applies is preponderance of the evidence. She has told us about the girl's demeanor, that they are agitated in that moment, and they say that JT has a gun. I think that to apply the exception, I think that is sufficient for the court to find that it was that they had firsthand knowledge. They were coming and asking for help in that moment, and that it was spontaneous in that they are physically having a reaction to something clearly that they have just seen. And so on the preponderance standard, I think we've met that burden, and she should be able to testify as to what the girl said.
The evidence is admissible. I will allow it in. I will overrule the objection, and can we call the jury back out?
Yes, Your Honor.
All right, Chair, if you kindly bring the jury back out, and let's go back and just stay there. Go back.
Yes,
Sorry about
okay,
that.
that's fine.
I keep wanting to call you know that. Go
People
back.
do.
Please stand for the jurors. Looks like 14 years in.
Okay, and Mr. Jenkins, if you maybe back up a question or two, and you may proceed with your direct examination.
When we took the break, we had spoken about the question was, what made you warn Dr. Parker, right? And do you remember answering about what did? Let me ask you that. What made you warn?
Your Honor, I don't object. There's been no testimony I believe you just said one, Dr. Parker. There's been no testimony of that nature.
I'm sorry, I apologize, Judge. Let me withdraw that. That's correct. I need to rephrase that question. That's correct about that. The question was, at some point later, do you tell Ms. Zwerner to keep an eye on JT? Did you?
Yes.
Okay. And what happened to make you give that warning to Ms. Zwerner?
So the girls had reported to me, had come up to me as I was passing, right after they came in, to say that he had a gun in the bag. And I went into that room with the children and to him to try and see what he would say, to see if I could help and figure out what was going on, because him and I had a good relationship due to the modified schedule.
Okay. And without telling us what you or he said, did you, at that stage, get any information about a gun out of him?
I told him the rules of school, that we cannot have any guns in school, we cannot have any type of weapon in school, and I asked him if he had a gun in the bag.
Okay.
And then we went on with the lesson. He was acting very weird that day, out of character, balled up. I just sat quietly by him. His bag was by him. I said, give me that bag. He said, no one is going to touch that bag, which was very out of character. He also was talking about one of his friends at the time, Omar.
You're not, here's the objections to what you testifying as far as what JT said.
So sustained damage is kind of the narrative. Can you ask another question?
I can. Thank you, Judge. After you had observed these things with JT, did you talk to Dr. Parker?
Not at that moment.
Okay. What did you do as a result of what you observed?
So what I observed is it was time for them to do their assignment. And so JT asked for some school supplies. So I went up to Ms. Warner and I said, he needs these school supplies. And I asked her when recess was, that I would be back when recess was, and I was going to check that bag.
I see. At that point, did you go and speak with Dr. Parker?
Yes, I did. At that point, I left the room right away and went to Dr. Parker's office, and I reported.
Hold on just a minute. At the time that you go to Dr. Parker's office, do you know what Ms. Werner's class was going to do?
They were going to head to recess.
Okay. And when you went to Dr. Parker's office, what did you tell Dr. Parker?
I'm going to object hearsay. I believe it's going to be a statement that's going to be offered for its truth.
Response.
Absolutely not. It's being offered for the fact that Dr. Parker was given the warning, not for whether the warning itself is true. It's not being offered to show that there is a gun. It's being offered to show that Dr. Parker was told there was a gun.
Mr. Rogers, anything further?
Again, the truth that there was, I guess what he's saying, there was notice, that's a very important fact issue in this trial. So it's offered for the truth of there was a warning.
Mr. Jenkins.
I am offering it for the truth that there was a warning. I mean, absolutely. But I'm not offering it to prove there was a gun. And also, Judge, it's a present sense impression. If the court were to find that it's hearsay, which I certainly would argue that it is not, it's also a present sense impression. It's an excited utterance, for that matter. It's not offered to prove the fact that there was a gun. It's offered to prove that she was told there was a gun.
Let's pull up the hearsay rules.
Judge, if I could direct the court to a particular rule and section.
You may.
2801, subsection C, which reads, hearsay is a statement other than one made by the declarant while testifying at trial or hearing that is offered to prove the truth of the matter asserted. So this does not meet the definition of hearsay for two reasons. First, we are not offering it to prove the truth of the matter asserted. And second, the declarant is testifying at the trial. The declarant in this case is Ms. Kovac.
And response from defense.
Your Honor, I'll say the rule. Hearsay is a statement other than one made by the declarant while testifying at trial. Anything that was said outside of her statement on the stand is a statement other than while testifying at trial. So if she said something to Dr. Parker that's other than while testifying at trial, she can testify as to what she observed, but she cannot testify as to something that she said to somebody else.
So the court's ruling is that it is admissible. There is an exception to hearsay, not only under Rule 2:801, but under Rule, because it's hearsay within hearsay, is what the children told her that she really relays to somebody else. So under 2:805, hearsay within hearsay, it's not excluded if each part of the statement can come in under another exception. So the children's statement comes in under the cited utterance, so therefore it can come in as hearsay within hearsay. So I will overrule the objection, which means to the jury you can consider the response. Repeat your question, Mr. James.
Very simply, what did you say to Dr. Parker?
I went to Dr. Parker and I told her that two girls came to me and said that JT had a gun in the bag. And I told her that, that's what I told her, that I was warned that he had a gun in the bag. I told her what I did in the classroom, that I sat in the classroom with him, that he was acting very weird that day, out of character.
Okay, and so you relayed that information to her. Ultimately, was there a discussion about any additional action that would take place related to the bag?
I told her that when they go to recess, that I was going to go back and check the bag.
Okay, did Dr. Parker respond to that?
She had just acknowledged it with like a nod.
Okay. All right. So, what did you go check the bag?
At that point, I left. We were doing makeup state testing, so I went to my office, which is past Ms. Warner's room. And Ms. Warner had texted me at that point.
Okay, I'm gonna have you hold off right there.
Okay.
So just jump with
So
me.
I went-
Okay. Did you at some point go to the room?
Yes.
Okay. And
Yes.
what
So
did you
I
do?
went- When they were at recess, I went back to the room. I checked his bag. Inside his bag was a puzzle, a math book, a little coin token, and then a calculator in the front pocket.
Okay. And what happened next?
After I checked the bag, I went back to Dr. Parker's office to let her know that I checked that bag. I told her the same items that were in the bag that I had seen.
Okay. And what did you do next?
After that, I went back and I went back outside to Abby and the class that was outside at recess.
Okay, I'm going to pause you right there. While you're outside at recess, without saying what anyone said, were there discussions among the teachers?
There was only her outside with her class at that time, and then I came outside at that time.
Did you and Abby talk?
Yes.
And had you and Ms. Zwerner, again, without saying what the content was, had you and Ms. Zwerner also communicated by text message?
Yes.
Okay. Now, as a result of those communications, again, it doesn't matter what was said, What did you do next?
So, from the result of the text, I then went and checked the bag. I then went and reported a second time to Dr. Parker. Then I went outside to speak to Abby to see if he would come to me because of what she had said in the text. So he was behind the rock wall, did not come to me. And then I told her again.
But wait, you told who?
I told Abby.
Okay. Are there two conversations with Dr. Parker?
There were technically, there were 2 times I reported, and then 1 time I was in the office, and then Dr. Parker had told me that I could tell Abby an action to do if he misbehaved.
Okay. What prompted the first time you talked to Dr. Parker briefly?
The report of the gun.
From the girls?
Correct.
Okay. Briefly, what prompted the second time you talked to Dr. Parker?
The message that I received.
Understood. In the second conversation with Dr. Parker, what did you advise her of?
I advised her that the weapon in discussion was now in his jacket pocket.
And that was your belief?
That was my belief.
Okay. You mentioned that you had been at recess. At recess, did you have an opportunity to see JT?
I did not.
Okay. According to your understanding at the time, what was the protocol for teachers or faculty members to follow when they believed there was some sort of crisis developing?
According to the Rich Neck Handbook, we were to report to our administrators.
Your Honor, I'm going to object. Hearsay, talking about something in the handbook, it's being offered for true.
Response.
Your Honor, I just asked if she knew it, and it is knowledge that she had. She's not reading from anything. She doesn't have the handbook, so she's just saying that she has that knowledge of the policy.
I will allow parents to overrule.
Ms. Kovac, I want to take you to the moment on January 6th that a gunshot has happened. Do you recall that moment?
Yes.
Okay. And what was your first thought and what did you do?
My first thought was, he had that gun, he shot it, and I walked in that room. He
By-
needed me
By in that room,
in
you,
Abby's room, room 11.
okay.
He
And-
needed me.
Okay, hold on. Let me walk you through it. When you walk into the room, what do you see?
I walk into the room, Abby is to my left, and I see blood on her leg, so I know she was hit. To my right, the children are running out and screaming, going across to the hall to the open door. And he was standing right in front of me, arms crossed, legs spread, and cocky.
Okay. At that stage, do you see a gun anywhere?
I do. It's on the left, my left, slightly under the reading table.
Okay. Did you go to Justice?
I went
I'm
straight-
sorry, JT.
I went
apologize.
straight to him. He did not resist me. I took him by the wrist because I knew he shot left-handed. He's left-handed. I didn't want to ruin the gunpowder. Watched enough shows. I took him to the front of the room. I sat in Abby's chair. I put him in between my legs and my arms, and I picked up and I called 911.
Okay. And then after you did that, do police eventually arrive?
Eventually, it felt like eternity.
Yeah. So when they arrive, what position are you in? Are you still that same?
I'm still in that same position. So we were facing, like the phone is here, and we were facing as the police were coming in.
Okay. And as the police are coming in to the room, what is going on with JT? What is he doing?
You know, I'm going to object to relevance at this point. It's not relevant to these proceedings at this point. What happened after the gunshot, and whether Dr. Parker is guilty of anything. We've gone beyond what's relevant here in this presentation of this witness.
Your Honor, the statute contemplates the event. I'm sorry, there couldn't be anything more relevant. The event of the shooting and its immediate aftermath is precisely what Dr. Parker is charged with. The effect of her omission is what we're hearing right now. And so this is the very circumstance. It is the immediate shooting and its aftermath, and its after effects for these children. And what she's describing is a present sense impression of something that is occurring as it's occurring.
So I will overrule the objection in terms of it's part of the incident and the immediate aftermath. Now the ongoing effects, there are going to be some limits on that. We can't talk about, I don't expect to talk about things more than 2 hours after this incident. Are you going past that?
Not with this witness, Judge, but with children and families that experienced ongoing effects from the neglect, but not with this witness.
Okay. And we'll take that up at a later point. But yes, you may continue with this witness. Objection overruled.
When police arrive, that's the part we're talking about. What is JT doing?
He is in my arms, and they asked me if, I was okay, and if he was okay, and we were both okay. He became more agitated and cussing up a storm, and eventually, he was just spewing cuss words, stating, that he...
Your Honor, I'm going to again object to relevance here. And also the fact that this testimony is really more prejudicial than probative of any element of the offense.
Any response?
I think the court has already ruled on that.
We didn't talk about prejudicial versus probative. You want to respond to that portion of the objection? That's a new objection.
Sure. All of the Commonwealth's evidence is prejudicial by definition. The question is whether it is probative. Probative is another word for relevant. Dr. Parker is charged with neglect of children that caused a shooting, and the testimony is about the shooting and its immediate after effects while there is still a gun on the floor, while police are arriving. So it is relevant, it is probative, highly probative, and therefore admissible.
So to the two-part objection from the defense, the court overrules it. The first part I previously ruled, so I note your continuing objection. As to the second part, prejudicial versus probative, it has to be, I think, substantially outweighed according to the admissibility standards in this case. Therefore, I rule it. I'm going to allow the testimony. You may consider it. Do you need him to repeat the question?
No.
Okay, you may finish your answer.
Okay, he was in my arms, he was getting agitated, he was cussing. I told him Mrs. Kovac does not like that language. He turned, gave me the finger, and then when I turned my head back, he punched me. My glasses went off, and I said that I was done, and I turned him over to the police.
Okay, and at that point, did you leave the room?
At that point, I did leave the room.
Okay, thank you. Now, Ms. Kovac, if you know, were police wearing body cameras while they were in there that day?
I knew that the one police officer said that he had the body cam on and got the whole transaction and my assault on the body cam.
If I were to show you a still picture from that, would you be able to recognize yourself and JT?
Yes.
Judge, I'm going to ask permission to show that to the witness at this time.
Okay.
And are you approaching the witness stand, or are you going to display it on the television?
First, I'm going to show it to defense counsel, then approach the witness stand until I've laid a foundation to show it.
Oh, yes, sir, thank you.
May I approach the witness, Judge?
You may.
I'm just going to ask you to take a look at that. Can you see it clearly?
Yes.
I'm going to return and ask you some questions.
Okay.
Ms. Kovac, having had a chance to look at that still frame, does it depict you in the exact setting and circumstances that you've just testified to?
Yes.
Does it appear to you to be a fair and accurate representation as a still of a moment of that interaction you've just described?
Yes.
All right. Judge, I am going to move to admit this into evidence as Commonwealth's 1. It is a video that is approximately 2 minutes and 51 seconds. It depicts the things about which she has testified.
Your Honor, she was not showing video. She was showing effectively a picture that showed her sitting with this child in her arms. There's no way, based on that, just seeing a picture, that she can properly authenticate that video. So what we need to do is exclude the jury, let her see the video, and then she can testify that what that video portrays accurately describes what occurred on the day. But right now, just based on a picture, that doesn't authenticate, effectively it's a picture, doesn't authenticate the video.
Your Honor, additionally, Your Honor, I believe the video is cumulative. And again, it's just shown to prejudice Dr. Parker. It's the prejudicial value substantially outweighs any probative value that a video of the interaction would have.
Judge, I'll address the first one. It sounds like it's an authentication objection. I was hoping we would avoid sending the jury out, but counsel is right. If we, to authenticate the video, I need to show her the video and let her authenticate it. So.
Okay, yes, because you said it's still photographed.
That's right.
Now we're talking about 2 minutes and 51 seconds. But I mean, if you could just play it without the volume, if that's adequate, I don't know, then she can just watch it
For-
right there in the witness stand.
for
Now,
her-
Before we publish it.
Yes, without the audio for her purposes.
But yes, if that's sufficient for authentication, and again, I don't know, I haven't seen it.
That's sufficient for me.
Okay.
I don't know if
And then what
counsel.
was the second objection, prejudicial versus probative?
And cumulative, Your Honor.
And say, I didn't hear you.
Cumulative.
Cumulative. Okay. So I overrule on both of those. And Mr. Jenkins, are you able to play it?
Yes, Your Honor.
Witness. And so again, he's going to approach and play it pretty silently. Yes, ma'am.
We're still having trouble here.
Still having trouble hearing them. Okay. Mr. Rogers, I don't have a microphone. I don't know what we can do to help you, but they still can't hear you.
Yes, ma'am.
Nobody ever has trouble hearing me.
And we're just going to sit quietly while this, I show you the witness. And while she's watching that, should she be able to state that it's a fair and accurate representation, are you going to put it on the big TV?
That is the plan.
Is the podium turned on? It takes about 2 minutes to warm up.
It is on. I
Okay,
tested it
that's what I
earlier.
was gonna say. I was gonna say, get it started if it's not started.
It looks like someone has changed the TV since I tested it earlier. Though,
Okay,
'cause
so we
it's,
need to let's find the right source. Input.
Okay, great.
that's it. We're good.
Your Honor, could I just add to our objection to the video? Your Honor, our client is discharged with 8 counts of abuse and neglect of children. What happened to Zwerner is tragic. And the behavior that Ms. Kovac had to endure on that morning after this shooting event, that was tragic also. But I believe she testified, that the shot was fired. She turned around and went into the room, and as she was going into the room, the children were leaving the room.
What's your objection?
There were no children present. They weren't at the moment that she's about to testify, there were no children that were subject to abuse and neglect.
Okay, this sounds like a motion to strike, so I'll hear that then. Okay.
It's done.
Okay, may I approach, Your Honor?
You may.
Ms. Kovac, you've just watched a video. I'm sorry, is that yes?
Yes, sorry.
Thank you. Does that video fairly and accurately show what happened in those moments that you were just describing in your testimony?
Yes, it does.
Judge, I do move the video into evidence as Commonwealth 1.
Defense,
We've
you
already
already objected, so there's some noted, no parole, and you may play the video. This will be marked, again, you said Commonwealth 1?
Commonwealth 1, Your Honor, and for the purposes of the media coverage, this video, we have muted the name of JT and Judge, I'll provide what the court has ruled to be Commonwealth 1. It is a USB drive inside a envelope labeled Kovac JT in classroom. May I approach?
You may, and so marked and so received.
Thank you, Ms. Kovac. I don't have any more questions for you, but please answer any questions from defense counsel.
Your Honor, before I start my cross-examination, can we take a brief recess?
Okay.
Or can I just step out?
Yes, you can step out. We'll just be quiet. Yes, sir.
Now,
All right, please do.
Okay.
name is Amy Kovac,
Yes,
and I believe you testified that you have been a reading specialist for 16 years?
13 years.
13 years? And how long have you actually been a teacher?
33 years.
A lot of experience in the school system.
Correct.
Is that entire time with Newport News City Schools?
No, the first 10 years were in King and Queen County. I've been with Newport News for 23 years.
Okay. All right. And would you agree that you had actually spent a lot of time with JT prior to this incident?
On the modified schedule, yes, so from October through January.
So you were used to his ups and downs, is that correct?
Correct.
Okay. He had good days?
Yes, with me.
Okay. And obviously, even prior to this day, he had some bad days.
Correct.
Would you agree that the Wednesday prior, just immediately prior, he had a bad day?
Correct.
Were you there to see and observe his behavior on Wednesday
In the classroom,
after the classroom incident?
I was in the office when he was brought up.
Okay. All right. And are you aware who brought him up?
Mr. Rawls,
Okay. All right. Do you know why he was brought up?
he didn't tell me then. I called for the buses at that point.
Okay. But you knew there was an incident in the classroom, that he was brought out of the classroom? Is that correct?
I knew that he was in an incident and was carried to the office.
Okay. All right. Okay, good. All right. So would you agree that it's the teacher's responsibility, primary responsibility, to make sure that the students in their classrooms are safe and protected from any harm?
It is the teacher's responsibility to teach the children, to have a schedule for the children, and to handle disruptive behavior, not excessive behavior, is my understanding.
Okay. So you would agree that if there's a disruptive student in the classroom, the teacher has the authority to remove that child from the classroom?
She can usually call for help. That's what I would do.
So you're saying no, a teacher cannot remove a student from the classroom for disruptive behavior?
I mean, to another classroom. It just depends on what the classroom plan is and the school's rules are.
So yes or no?
I don't know.
You don't know. Okay. All right. Have you ever removed a student from a classroom for disruptive behavior?
In my classroom as a general ed teacher
Sure.
or as a reading specialist?
A general ed teacher.
Yes, I've moved into another classroom.
Okay. All right. You would also agree that a teacher has the ability, if a student is disruptive, to take them down to the administrative office.
If there's someone to watch their class if needed.
All right. So obviously, you don't want to assign any blame or responsibility for the classroom teacher for JT's behavior on that day. Is that correct?
Objection. This calls for speculation, is an opinion about whether she wants to assign something to someone.
I'll let the court rule on it.
This cross-examination, he's allowed to forward back the witnesses.
It's not my place. I mean, I don't know it. I can't think for somebody else. I can only think for myself.
Okay. All right. So let's start when you first became aware that there may be a problem with JT. Okay. I believe it was the incident with the two young girls. Is that correct?
For that day?
For that day.
No, that was not the first time.
Okay. What was the first time that you had any kind of indication that JT was having a bad day?
When Ms. Zwerner came in to report that he had been acting up in the lunchroom, and she was reporting to Ms. Parker, myself and Ms. Harris were in there because it was testing, and we had just returned our tickets. Dr. Parker did not look up at her, did not acknowledge her.
Okay. You did not observe this behavior yourself. This was just something.
I did observe that behavior.
What observed? What?
Not Justin's behavior.
That's what I'm talking about. I'm talking about JT's.
But Dr. Parker and Adam's behavior, I did observe.
Okay. All right. And then you had the encounter with the two young girls. Is that correct?
Correct.
All right. And so it sounds like, based on your testimony during direct examination, that that you believe the girl's assertion that JT had a gun. Is that correct?
Correct.
Okay. So obviously if JT had a gun, then he presented a danger to the students in his classroom. Is that correct?
Correct.
Okay. All right. So you went to investigate that. Is that correct?
I walked into that classroom
All right.
to speak with him,
With the belief that he had a gun. Is that correct?
with the belief that there was a possible weapon.
Okay. All right. And so, and you observed that he was acting off. Is that correct?
Correct.
Okay. You, along with his teacher, had the authority to remove him from the classroom. Isn't that correct?
We had already told her that
I'm talking about your authority. You had the authority, along with Miss Zwerner,
I
to.
don't know.
Okay. All right. But even with you indicating that you believe that he had a gun, you spent some time with him, and then you left him in the classroom, even though you believe that he had possessed a gun. Is that correct?
I left the classroom to report as required by my school.
If a student had a gun, don't you believe it's required that you separate that student from the other students so he doesn't present a danger of harm to those students?
Objection's been asked and answered 3 times now.
Response?
Your Honor, I'm just trying to make sure that she clearly indicates what her responsibilities are regarding the safety of the children.
Ask it one last time.
For the safety of the children, I did not remove him at that point.
All right. So, and so then you said that you actually spent some time on the playground when JT was with his classmates. Is that correct?
I went out to the playground, did not spend time. I was testing and had to get back.
But you believe that he had a gun on the playground. Isn't that correct?
I'm not sure what kind of gun, I'm not sure what kind of weapon. I had not seen it myself. I only heard the reports and I reported as required
But you said you believed it was a gun. Is that correct?
because the girls reported.
And you believed them.
Any report of a weapon in a school, I'm reporting, and I did,
All right. Is there
more
a
than once.
is there a possibility that you thought it was a toy gun versus a real gun?
I don't know, I mean, my personal thoughts are my personal thoughts, so,
Did you express to anybody that you thought it was probably a toy and not a real gun?
yes, after the incident, the police have it on police cam. That was my thoughts while I was in shock.
Okay. So you believe there was a real gun, and then you left the other
I did
student.
not know if it was a real gun or not when I was in the room with him.
So you didn't believe that he had a gun.
Objection, Your Honor. He is misstating her testimony over and over within his questions.
Response, Mr. Rogers?
Your Honor, she's trying to have it both ways. She indicated on direct examination that she believed he had a gun. Now that I am assigning her responsibility to her, she's trying to say that, well, I don't know. What I believed at the time, she's acknowledged that she did tell somebody that there was a toy gun. So I'm just trying to narrow down whether or not she believed it was a gun or not.
Okay, and your objection to fleshing that out is what, Mr. Jenkins?
It's that she has already said the answer. She has already said that it could have been any kind of gun she didn't know. And he keeps restating her testimony differently than that. He keeps saying, you believed it was a gun. And she keeps saying, I didn't know if it was a gun.
Well, I think he switched to her stating something different purportedly on the body cam that now it's a toy gun. And again, strong cross-examination, vigorous cross-examination is fundamental of our justice system. So overruled, you may proceed, Mr. Rogers.
Your Honor, may I address one other issue?
Yes.
I'm hearing in the courtroom gallery commentary for coming over my right shoulder. I just think the gallery needs to be informed that they're not
Okay,
speaking.
and I can do that. And I heard something, I just couldn't tell the direction. I need absolute silence from participants in the courtroom. We cannot comment, we cannot bolster, we cannot suggest our opinions in any way. And please govern yourselves accordingly. This is an open public proceeding, but if people are disruptive, they will be asked to leave. Comments are considered disruptive, and I can't close this courtroom. I'll ask everyone to govern themselves accordingly, and I think the sheriff will start keeping an eye out for that. I know he was. So sheriff, if anybody's making noise, please escort them out. Thank you. All right, please proceed, Mr. Rogers.
Thank you, Your Honor. So it sounds like now you're saying that you weren't sure if he possessed a firearm. Is that correct?
What I'm saying is, the girls reported that there was a gun,
And you believe them?
and I,
Objection, Judge.
Yeah, let her finish her response, Mr. Rogers.
I acted on the report. Children were 6 years old, first grade. I acted on the report. I went to see what was going on with him. I did not look in the bag. I did not touch the bag. I was in the room. When I left the room, I went and reported to my administrator.
Did you leave that?
Are you finished your response?
Yes.
Okay, next question.
Did you leave that room believing that there was a gun?
I left that room believing that there was something in that bag.
Something that potentially presented a threat of harm to those
Now,
children?
this is ask and answer, Mr. Rogers.
All right.
Next question.
All right.
Move on.
All right. And then let's talk about the playground. Same thing, right? You knew that JT was out on the playground, is that correct?
Correct.
All right. You said that you didn't visually see him yourself, but you knew he was present, is that correct?
Correct.
Okay. He was out there with his classmates, is that correct?
Correct.
All right. Miss Zwerner, his teacher, was out there, isn't that correct?
Correct.
Okay. There was nothing that prevented you or Miss Zwerner on that playground to separate JT from the rest of his classmates, isn't that correct?
No.
All right. So you said that you searched his backpack, is that correct?
Correct.
Okay. After you searched his backpack, did that dispel any fears that you may have had that he possessed a firearm?
No.
Okay. So you continued to think that he potentially had a firearm, is that correct?
Something. He had some kind of weapon.
When you say some kind of weapon, are we talking, are
We're
you,
still
are you,
talking gun because that's what the girls reported. I did not know what was in that bag.
so are you holding out the possibility that it's a toy gun?
I am not sure what it was.
Yes or no?
It could have been, yes.
All right. So if it was a toy gun,
We still report and we still investigate.
I got you, but it's not a toy gun is not a threat of harm to the children, isn't that correct?
If there is a report, it is required by the state that you report.
Do you
And
understand
I
my
did
question?
report. I do understand your question.
Okay, does
Okay,
it,
hold on, for everybody, we're gonna lower the temperature in the room. So the objection would be non-responsive, because she did not answer your question, she answered a different question. Can you repeat your last question, Mr. Rogers?
do you believe that a toy gun presents a threat of harm to those students?
He couldn't. Yes, yes it could.
Okay, explain. How in the world a toy gun could present
A
a...
BB gun, a water gun.
I said,
Any kind.
my question was...
Objection.
She answered the question, what's the next question?
Okay. So you consider a BB gun as a toy gun, is that correct?
It's a gun. You report for any type of weapon. I reported.
All right. Just going back a little bit, when the girls made this report to you, did you take them down to the office to speak to administration?
I did not.
All right. Do you think it may have been important to take them down to the office too?
I did the actions that I did in that day, and I cannot look in retrospect.
Okay. Who gave you the authority to check the backpack?
According to the crisis plan, we are allowed to. We just cannot check your body without permission from the administrator.
Okay. So did Dr. Parker give you the authority to check the book bag?
She acknowledged when she heard that I was going to do it. She could have gotten up and done it herself if she wanted to.
Okay. So let's talk about, you said you're a part of the crisis, what is it, crisis management team?
I'm not part of the crisis management plan. I said in the crisis plan
Are
that
you?
the district holds.
So you're not a part of the crisis management team or any kind of crisis team at the school?
No, I am the reading specialist, and If the principal and administration gives me another duty, then I do that.
Okay. But nobody told you, Dr. Parker or otherwise, that you did not have the authority to remove JT from the classroom. Is that correct?
No.
When the police arrived and you were holding JT, were there any students in the classroom?
No.
Okay. At what point did the students leave the classroom?
When I was walking in, they were coming out.
Okay. So by the time that you took a hold of JT and sat down with him, there were no students in the
There were
classroom.
students in there.
Zwerner, can I have a moment?
Okay?
After the firing of the firearm by JT, one of the steps that you took was to call the police. Is that correct?
Once I had a hold of it, yes.
Okay. So that phone was readily available to contact the police?
It was her school office, her school phone.
Okay. Were there also walkie-talkies that could be used to communicate with administration?
There is, but I did not have my phone or my walkie because testing had just finished. And state testing, we cannot have that. So I had none of those.
But you did have the classroom phone that you could have easily called down to the administrative office. Isn't that correct?
After the shooting, I did call. It was busy the whole time.
All right. So before then, you took no steps to call the police. Is that correct?
Correct.
And okay. So, but you did communicate with administration face to face. Is that correct?
Correct.
All right.
Several times.
After the incident, did you have communications with Dr. Parker?
Yes.
Okay. You understood that she was very upset about what the things that occurred on that day. Is that correct?
Well, first of all, I was in shock that day. I did speak to her. We were considered work friends, so I checked in on her. I asked her if she called her husband. I asked her if I could use her phone to call my husband.
Okay. And you indicated to her that the events that had occurred on that day were unfortunate.
Objection, hearsay.
Okay, so go ahead to finish your entire question, and then I'll move on to the next.
You indicated to her by some communications, by text or in person, that you believe that the events that occurred on that day were not foreseeable. Is that correct?
Okay, and hold on, that's where I'm going to go. Okay, and your objection is what? If you flesh out a little bit more, Mr. Chambers.
So he's asking about an out-of-court statement offered for the truth of the matter. He's asking about an out-of-court statement that she said to Dr. Parker. So that is hearsay.
Response.
I'll submit it to the court.
So suspend. All right, so do not answer. Next question, if any.
Okay. And so, just briefly going back to the backpack. So, you searched it, didn't find anything that you believe presented a danger. Is that correct?
Not at the time, correct. Yep.
Okay. You Did you observe at all JT on the playground? Did you observe what he was wearing? You know, anything
No.
that he may have had in his pockets?
No.
All right. All right. Your Honor, I'm going to check with my co-counsel one more time, and then I think I'm done.
Yes, sir.
I'm sorry, I just want to return to the backpack again. When you asked JT to search, to let you look into his backpack, and he said no, was that alarming to you?
His actions were alarming to me.
Okay, but
Words that come out of his mouth, it's hot and cold every day.
so you're saying you didn't take that seriously?
I took it seriously because I reported 3 times to the administrator.
Okay, but not seriously enough to say, let's take JT to the office, or let's get his classmates out of this classroom, because I think that...
Objection asked and answered.
Talking about the backpack now, Your Honor.
I'll allow it. Go ahead.
All right. So not enough to take JT's classmates out of that room for any potential harm.
I did not know what his next actions would have been at that moment, and to keep the children safe if there was something, because a weapon had been reported and no administrator did actions.
Okay, so you could have taken some steps to keep them safe.
I did, as what I could at that time.
Okay, so that's all you could have done is reported to the administration. You couldn't have taken JT out of the classroom. You couldn't have taken the students out of the classroom.
In retrospect, maybe, but I did what I did.
All right. That's all the questions I have.
Can you redirect?
No, Your Honor. Thank you, Ms. Kovac.
And this witness status in terms of being sequestered, excused?
I would request the same with all of our witnesses. I'm asking that she remain sequestered but be able to leave. Certainly she is subject to recall by either party.
I agree.
Okay, so, Ms. Kovac, you are welcome to leave the building, but you are still a sequestered witness, meaning you cannot discuss this case until the trial is over. And it's my understanding that attorneys have your number, so if they need to call you back for subsequent testimony, please be available. All right, thank you, ma'am. Please step down. And again, you're welcome to leave or stay, but you can't stay anymore. Okay, we do another witness, got about 20 minutes before we break for lunch. We start with another witness.
Judge, I have one witness that we could do, I think, very quickly.
Okay, who would you like to call, please?
Deputy Bly.
Bly?
Bly, B-L-Y-T-H-E.
Okay, thank you. One moment. Sheriff, Deputy Bly, please. Thank you. Good morning, sir. Please stand in front of the clerk and get sworn in.
Do you swear affirm the testimony you're about to give is the truth, whole truth, and nothing but the truth?
I do.
All right, please take the witness stand. Watch your step, and you may adjust the chair and microphone. Counsel.
Good afternoon, sir. Please tell us your name.
My name is Thomas Bly. I'm a retired deputy from the Newport News Sheriff's Office.
And were you working as a deputy on January 6, 2023?
I was.
And on that day, Did you have occasion to go to Rich Neck Elementary School in Newport News?
I did. I responded to a radio call of an active shooter at the school.
All right. And did you go to the school?
Yes.
And what did you do when you arrived?
Pulled up in front of the school. Deputy Briggs about a half second behind me. We went to the door, tried to get in, but the intercom wouldn't work at the door. There was nobody to meet us. Everything was locked up. We were joined by a couple of Newport News police officers. All four of us pounding on the windows, yelling, trying to get somebody to open the door for us.
Okay. Did you observe an intercom system of sorts on the door on the outside?
There was an intercom on the door. It didn't appear to be working, or at least nobody was answering it.
Okay. Eventually, does someone let you in the door?
After about a minute, it was either, I think it was a janitorial staff.
Okay.
Opened the door for us.
And roughly how long were you out there prior to a janitorial staff opening the door?
I think by the body camera it was about a minute, maybe a minute and a half.
Okay.
Felt like an turner.
Yeah. Were you armed and willing to go in and confront?
We were in full uniform, armed, responding to what we thought was an active shooter.
All right, thank you. I don't have any further questions for you. Please answer any from defense counsel.
No questions, Your Honor.
Thank you. Does Detective Bly need to remain?
No, I actually, if there's no objection, I think he could be released. Yes, so we would like to release him from recall.
Okay, to confirm defense position.
No objection to him being released, Your Honor.
Okay, so thank you, Detective, for your testimony. And being released means you are welcome to stay in the courtroom or you may leave. Thank you, sir.
Thank you, Your Honor.
All right, next witness.
Judge, my remaining witnesses may take a bit more time than that one. Do you want to go
I would like
forward?
to, yeah, I would like to start. Yes, please.